Under Rule 10b-5 of the Securities Exchange Act of 1934, or the Exchange Act, a publicly traded corporation can't buy its own stock based on material non-public information. In the 1987 case Jordan v. Duff and Phelps Incorporated, the Seventh Circuit considered whether a closely held corporation, or a corporation that's privately owned by a few individuals, has a duty to disclose non-public information of a merger before purchasing its own stock from a shareholder. Duff and Phelps is a closely held financial advisory firm. In May of 1977, James Jordan began working for Duff as a securities analyst. 4 years later, Duff offered Jordan the opportunity to buy stock in the corporation. By November of 1983, Jordan had purchased 188 of Duff's 20,100 shares outstanding and was making installment payments on another 62 shares of stock. Before buying Duff's stock, Jordan was required to sign a purchase agreement. Under the terms of the agreement, if Jordan was to stop working for Duff for whatever reason, he was required to sell his stock back at the stock's book value at the end of the year preceding his termination. In November of 1983, Jordan informed Duff that he was resigning at the end of the year. At the time, Duff was negotiating a merger with Securities Pacific Corporation, although no agreement had been reached. Jordan wasn't aware of the negotiations and didn't ask about a merger. After working for the rest of the year, Jordan received a $23,225 check in the mail for his 188 shares in Duff. But on January 10, 1984, a merger was announced between Duff and a subsidiary of Securities Pacific, which valued Duff at $50 million. Based on the valuation, if Jordan had waited to resign until after the merger, he would have received $450,000. Jordan then refused to cash his check and demanded that Duff return his stock, which Duff refused. Subsequently, in March of 1984, Jordan sued Duff for fraud in federal district court seeking damages. While suit was pending, the merger failed, and Jordan amended his complaint to seek rescission of his stock. In response, Duff moved for summary judgment, arguing that it didn't have a duty to disclose information about the merger to Jordan at the time of his resignation. The district court agreed and granted Duff's motion. Jordan appealed to the Seventh Circuit.